Hey class, welcome to week 12. Today we are going to cover how we hold agencies accountable via the public's ability to access records and attend government meetings. So as we've discussed, agencies are accountable to the public through judicial review, public access laws, and also liability. Keep in mind that the accessibility requirements, they really do affect a lot of what public administrators do. So as a public administrator, you should be aware that members of the public can get access to your emails, final memoranda, and other records that you might generate in the course of work. So in my job, we call this the Washington Post test because the University of Maryland's just a few miles from DC, and the Post is our local paper. We don't want to do anything that would look bad splashed across the front page of the Washington Post. We do want to be accountable to the public, and we don't want anybody to be sneaky and try to hide information. And that's because transparency really is the best option for the vast majority of government work, with obvious exceptions like national security or personally identifiable information. Now remember, the subject of agency accountability, it can be overwhelming because of the frequently dense legal materials involved. And as a public administrator, your job is not to act as an attorney for the agency. Instead, what I really hope is that this class helps you recognize potential legal problems and proactively take those potential problems to your agency's legal office. So there are three main statutes that make our government accessible to the public. There is the Freedom of Information Act, or FOIA, which allows the public to obtain written records from the government. There is the Privacy Act, which prohibits the government from disclosing records that relate to a private individual. And there is the Sunshine Act, often called an Open Meeting Act, that allows the public to attend government meetings. And you'll see here on the screen, they are all part of the Administrative Procedure Act. So public access, it includes the right to comment on proposed regulations, the right to access agency records, and the right to attend most agency meetings. I happen to be a big fan of Parks and Rec, so I could not help but include a photo of a Pawnee public meeting. If you happen to watch Parks and Rec now, you will notice so many administrative law concepts that you may have overlooked previously. The concept of public access to government records and meetings is very new in the modern world. At common law, not just in the US, but in England and other Commonwealth countries, the state was supreme. The state, much like a king or queen, had complete sovereign immunity, and the public had no lawful role to play in the way the government formulated rules and policy. Here in the US, Congress and state legislatures gradually began waiving certain aspects of sovereign immunity, and public access was one result. While the concept of public access to the government is new in the modern world, back in Roman times, and by that I mean the Roman Republic before it became the Roman Empire, the government actually required the publication of a daily public record called Actus Diurna, or daily acts. It included government notices, legal proceedings, outcome of trials, things like that. It operated a lot like today's Federal Register. And the Roman government issued this daily record starting in 131 BCE. So in Roman times, there was a surprising amount of public access, at least during the Republic. When Julius Caesar was elected to be the Roman consul, which was the highest elected office in the Republic, he actually mandated additional open government requirements. So he required that all the proceedings of the Roman Senate be published in a version of the Acta Diurna called the Acta Senatus. That made the Roman Senate's actions really transparent to the public, much like the Congressional record does today. Now, Caesar was a populist, and he was beloved by the public, but his intent really wasn't to open up government and allow more transparency for the public benefit. His real intent was to undermine the Roman Senate and consolidate his power by showing the public how much corruption was, within the Senate. Basically, he wanted to horrify the public with the sausage-making details of the legislative process. and he was hoping that by disclosing all of this information to the public, they would rally to his side and take his side when he opposed the Senate, and he was right. That is, in fact, what happened. So while there was public access in Roman times, in the US, we really didn't have public access to our government until the mid-1960s. There was actually a lot more of it back when our country began due to freedom of the press and the expansion of printing presses. So back when our country started, it was actually quite a lot like an earlier version of social media, because people would write up their opinions, have them printed as pamphlets, and then those were widely circulated. As we entered the era of broadcast media, public access to government information sort of decreased. And in part, this is because the government had grown so much that it became difficult to remain transparent and open. But additionally, a limited number of media groups controlled the flow of information, and so radio and TV made the public more passive consumers of information. As a side note, research has shown that Americans did not disagree so violently during the era of the big three TV networks, and that there was more civic engagement, and that is most likely because the news was pitched to the widest possible audience. So that meant that all Americans were getting approximately the same news, and those news sources were heavily fact-checked. So starting after the McCarthy era, the communist scare, the American public began to realize that the government was playing an increasingly significant role in the lives of individual citizens. A lot of this had to do with all of those New Deal regulations, as well as emerging technology, globalization of the world economy after World War II, etc. So it wasn't the public's imagination. The government really was more involved in the lives of people. Throughout the 60s and 70s, I guess I should say the 1960s and 1970s, revelations of government wrongdoing, most of which were made public by mainstream media, particularly newspapers, but those revelations prompted calls for access to and accountability in the federal government. Those government wrongdoings that angered the public were, for instance, McCarthyism, which resulted in the blacklisting of a lot of innocent Americans, as well as Watergate and the Vietnam War. So proponents of openness and transparency began to argue very strenuously that American citizens had the right to be more involved with our government and had a right to review and understand government actions that affected them. And as a result of the public outcry and the pressure from mainstream media, so primarily newspapers like the Washington Post and New York Times, as well as the big three news networks, Congress and state legislatures began enacting laws that gave citizens the right to see government records, attend government meetings, and comment on proposed regulations before they became final. So the first of these statutes that we are going to cover today is FOIA, the Freedom of Information Act. FOIA became a law in 1966, so it has already had its 50th anniversary. Today, like the other acts we're going to discuss, FOIA is part of the APA, and its purpose is to ensure an informed citizenry and advance democracy by acting as a check against government corruption. So it's basically a way to hold government officials accountable through transparency. Because if you know that the memo you write or the email that you send might be accessible to the public, you're probably going to be better about acting responsibly and ethically and otherwise in line with the law. And it is very likely that your memo or email will be available to the public because FOIA has a very broad reach. It creates a presumption of openness and disclosure. So FOIA assumes that the federal government is going to disclose records to the public. And it does this through three requirements: a publication requirement, an inspection and copying requirement, and the big one for FOIA, the production upon request requirement. The publication requirement should probably be familiar to you because we've kind of discussed it throughout the semester whenever we have talked about information that agencies have to publish in the Federal Register. So for instance, the fact that agencies have to publish draft regulations, that is part of the FOIA publication requirement. It's in the APA as well, in other spots of the APA, I should say, but FOIA bolsters that public notice requirement. Agencies also have to publish certain information on a regular basis, such as a description of their central and field offices, where they're located, how you can access them, statements about how the agency carries out its functions, that can include both formal and informal procedures, and how the public can obtain documents that relate to those functions. Additionally, any time that they change, remove, add previously published information, agencies have to publish that addition, removal, or change in the Federal Register as well. There is also the inspection and copying requirement, which requires that agencies make certain information available to the public. Inspection is just the right for the public to inspect or review the information, and as you have probably guessed, copying, that is the right to make a copy of that information. This began as what we call a reading room requirement. Agencies, pre-internet, had to provide a location for people to physically come in and review and make copies of documents. That could be ALJ opinions or agency interpretations of its regs, what have you. And originally, these reading rooms were physical locations, and they do still exist as physical locations. Agencies in DC, for instance, they do have actual rooms where you can sit and you can read through agency documents. But today, almost every agency also has an online or electronic reading room so that you don't have to make a trip to DC. Instead, you just go to the agency's electronic reading room and you search for documents that the agency has made public. That is what we're going to do during this week's discussion, which is a FOIA scavenger hunt through some old FBI records. And so these reading rooms are often populated with documents that agencies have released under individual FOIA requests, but these are requests that they get a lot. So instead of having to respond to every FOIA request, they go ahead and put those documents in these reading rooms. Okay, so we've reviewed two of the FOIA requirements thus far, publication and inspection and copying. Those are proactive methods of disclosure. Production upon request is a reactive method of disclosure, and it is what we typically think of when we think of a FOIA request. So if agencies have not already made information available, members of the public, and that includes businesses and other organizations, we can request this information. And agencies then have to make the information promptly available as long as the request is reasonable and it complies with agency time, place, and fee requirements. Now, whether a request is reasonable is somewhat subjective. Clearly, if you were to go in and request all emails ever sent by an agency from 1999 to present, that is going to be unreasonably broad, overly burdensome, and the agency will deny your request. Federal agencies handle over 2 million FOIA requests per year, so if you happen to make a FOIA request, you want it to be very specific. You want to ask for very specific records from very specific time periods, because the more specific you can be, the more likely it is that your request will be considered reasonable. And that's just because the agency is actually going to know what you want, know where to find responsive records, and it's not going to have to waste much time if you are specific in your request. This is an example of a FOIA request that the Electronic Privacy Information Center, or EPIC, submitted to the Department of Homeland Security. It's an old one, but I think it's pretty interesting. So EPIC was looking for government contracts, internal government trainings, intergovernmental communications, and a variety of security measures that related to the Department of Homeland Security's social media monitoring initiative. EPIC got involved after some emails were leaked to the press, and those emails revealed that DHS was paying a contractor to monitor, sabotage, and discredit online social media activity of American citizens. So Homeland Security was primarily targeting, at first, labor union activities, But then they were also looking at, blogs and Facebook posts, and it became a really broad review of Americans' social media activity. And we're going to talk a little bit about that later in the lecture. So once an agency receives a request like the one from Epic, the agency has 10 business days to determine if it will comply with the request. That is not 10 business days to provide the information. It is 10 business days to get back to the requester and say, yes, we are in the process of collecting your records, or no, we're not going to provide you with those records, or some combination thereof. If an agency denies the FOIA request, it is supposed to immediately notify the requester of that denial. So technically, if an agency knows on day 1 that it's going to deny the request, it should say so on day 1, but by law it has until day 10. The agency also has to explain why it's denying the request, and it has to inform the requester that he or she can appeal the denial to the head of the agency. Now, on the other hand, if the agency approves the request, it just needs to make that information available. It doesn't actually require that agencies provide copies, either hard copies or electronic copies. In fact, agencies can require that you travel to their location where the records are kept. But that's extremely rare. It's really easy to provide electronic documents. Anything from the past like 20 years is probably in electronic format anyway. Now, there is no fee to file your FOIA request, but agencies can charge a fee to recover some of the costs associated with processing that request. It can be incredibly burdensome to respond to FOIA requests. The person who receives the request at the agency is probably going to have to gather information from a whole bunch of different offices, and that's going to require that those offices stop their other work in order to respond to the FOIA request. At the state level, I have seen open records requests that will take hundreds of hours of staff time to fulfill. So it could be very expensive for an agency to respond to a FOIA request, and because of that, FOIA does permit the agencies to charge fees. And at the federal level, there are 3 categories of FOIA fees. If it is a commercial use requester, then they are basically charged for any and all search time, document review time, and duplication. If it's news media, educational, or scientific requesters, they only have to pay the cost of duplication after the first 100 pages. And then all other requesters are charged for the search time with the first 2 hours free, as well as the duplication after the first 100 pages. Now, you might be thinking, duplication? Like, why not just send the electronic copy? And the answer is that agencies have to redact documents so as not to disclose confidential or proprietary information. And sometimes that actually means printing out a copy, redacting it, and then photocopying the redacted version. So agencies can and do withhold records until that fee is paid, particularly if it's a fairly high fee. The highest open records fee that I have seen recently has been about $270,000, and that is where the requester wanted like a gazillion documents dating back over 30 years. So again, if you're specific about what you want and you narrow it to a good time window, you're more likely to get the information that you're requesting quickly and free of charge. If the agency does not disclose records requested under FOIA, it has to tell the requester, and the requester can appeal that denial. So if the requester files an appeal, the agency then has 20 days to decide on the appeal. There are some times when it can get a 10-day extension for unusual circumstances, which might be that the documents are located in a different physical location, so the agency might have to coordinate with field offices, or the agency has to search through an exceptionally large number of records, or it's such an old record that retrieving it is going to take time. If the appeal is denied, again, the agency's got to let the requester know about the denial, and also let the requester know that they can get judicial review by appealing that denial to an Article III court. Now, it is important to keep in mind that FOIA only requires the production of agency records. So that means records that are in the possession or control of the agency. Basically records that the agency generates, as well as records that the agency collects, usually from regulated parties. Agencies do not have to create a record if one does not exist. FOIA only requires that agencies release the records that they actually have. And these records can be redacted to protect confidential information or other information that FOIA exempts from disclosure. And speaking of, FOIA has quite a number of exceptions to disclosure. FOIA calls them exemptions at the state level. Some states call them exemptions, some call them exceptions, but they mean the same thing. The agency is not required to disclose the information. FOIA's exemptions are basically about protecting sensitive information that can really range from the contents of an employee's personnel file all the way up to U.S. nuclear codes. So I've got some of that sensitive information on the slide here. Now, most of FOIA's exemptions are permissive. They're not mandatory. So if a permissive exemption applies, the agency has discretion to either disclose the information or withhold the information from disclosure. FOIA does permit agencies to disclose private and confidential information, but the Privacy Act, which we're going to discuss later, prohibits agencies from disclosing this information about individuals. So even though FOIA technically would allow agencies to disclose, say your home address and your social security number, in practice, agencies cannot do that because that information is protected by the Privacy Act. If somebody makes a FOIA request and the agency refuses to disclose information and the requester sues, it is going to be up to the agency to prove that the information that it withheld is covered by a FOIA exemption. One mandatory exemption, where agencies have no discretion, they are simply prohibited from disclosing information, is the national defense and/or foreign policy exemption. To trigger this exemption, the President of the United States has to specifically issue an executive order requiring that those documents remain classified. Additionally, the documents actually have to contain or concern national defense or foreign policy decisions. The government cannot just pretend that the information is about national defense and foreign policy. The information has to be legit defense and foreign policy. There is a critical infrastructures exemption. We consider it to be new, and it's new because the other FOIA exemptions have been around since FOIA became law, but this critical infrastructure exemption was created after the September 11th terrorist attacks back in 2001. So, I mean, it's not new, but it's newer than the other exemptions. This one exempts from disclosure any data that owners or operators of critical infrastructure have provided voluntarily to the government. So critical infrastructure, that can include private infrastructure. It applies to communications, so you got cell phone networks or landlines or internet providers, as well as banking, healthcare, and utilities. And the reason for this exemption is that the federal government wanted to ensure cooperation from its private contractors, particularly in response to threats to critical infrastructure. And the best way to get that type of cooperation from private parties is to ensure that the information they provide cannot be disclosed under FOIA. And particularly, these contractors are worried about disclosure of their confidential business information to their competitors. And so this critical infrastructure exemption gets around that. Contractors know that their information can't be disclosed. They're more likely to give it and cooperate with the feds. There's also an exemption for situations where another statute prohibits disclosure. So while FOIA presumes openness and disclosure, there are some statutes that require that an agency withhold information. All of those statutes are incorporated into FOIA by reference. FOIA does not need to specify the name of a statute for this exemption to apply. It applies whenever there is a statute out there that specifically requires agencies to withhold information. And to fall into this exemption, the other statute cannot leave any room for agency discretion. If a statute says an agency may disclose, then that is permissive and it's not going to count for this exemption. Now, it is surprisingly common for statutes to require that agencies withhold certain information. So, for example, 7 U.S.C. section 4608G, that exempts certain information about honeybee handlers. And so if you were to file a FOIA request with the USDA, the agency would go ahead and deny that request based on this other statute's exemption. Similarly, the National Security Agency Act of 1959, that prohibits the disclosure of most information, pretty much all information relating to the NSA's activities. This is again a mandatory exemption. It is not permissive. Agencies have to withhold the information. And you may not know, but we actually have a National Honey Board, and they hold their annual meeting in Denver. A lot of the information that relates to the National Honey Board's activities and information about individual beekeepers is exempt. It's not to be disclosed under FOIA. You can see here the statutory language that exempts that information from disclosure. A lot of it is about honeybee research and other activities. And the statute exempts this information because honeybees are crucial to our environment and they have a huge impact on agricultural operations. There is also a trade secrets and financial information exemption, and it is one of the most frequently invoked exemptions to FOIA. So it applies to trade secrets and other proprietary commercial or financial information that agencies obtain from private parties, and that, if disclosed, could result in some type of competitive harm to that party or impair the agency's ability to get the same type of information in the future. Again, naturally, if a party thinks the government is going to disclose his, her, or its confidential information, that party is unlikely to willingly hand it over to the government. And the inability of agencies to obtain information can seriously hinder their ability to function. So agencies are not supposed to disclose trade secrets. The entire point of a trade secret is that it is secret. The moment it is no longer secret, the company can't protect the information as a trade secret. So if, for instance, the USDA happens to know Coca-Cola's secret recipe, the USDA is going to withhold that information from any type of disclosure as a trade secret. Now, there are times when agencies decide they are going to go ahead and disclose this information anyway. And when that happens, the owner of the information typically will sue the agency to prevent it from disclosing. We call that a reverse FOIA suit. And if it is successful, a court will quash the agency's disclosure and the information will remain confidential. Another fairly broad exemption applies to records that contain personal information, medical information, just generally private information. So agencies withhold files if disclosing the information in the record would reveal, personal information about an employee, such as a home address or a personal phone number. There are a variety of confidential HR records that cannot be disclosed. That includes things like disability accommodation paperwork. Now, this is a permissive exemption, so it's possible that the agency could release the information, but it has to carefully weigh the interests of the public in knowing the information and the interests of the individual or organization in maintaining their privacy. And agencies generally err on the side of caution and refuse to disclose these records, particularly, again, if it's about an individual rather than an organization, because the Privacy Act is going to apply. There is also a law enforcement records exemption. Agencies can withhold information related to police and other law enforcement activities and agencies if that disclosure would interfere with an investigation or endanger the life of a law enforcement officer or somebody else, or impair a fair trial or other adjudication, disclose the identity of a confidential source, or disclose investigative procedures. So basically anything that would impede a law enforcement agency's ability to do its job. For instance, where I work, we sometimes get requests for our active shooter protocol. We are not going to release that because we only want our police to know their active shooter protocol. If we were to release it, then people could find loopholes and figure out how to avoid that protocol. Agencies can also withhold anything that would be an unwarranted invasion of privacy. So for example, police records of attempted suicide or police records relating to domestic violence. Agencies can withhold those. Under the financial institution exemption, agencies that regulate banks and other financial institutions, such as the Consumer Financial Protection Bureau, they can withhold records such as operating reports and audit records. And the reason for this is that Congress believes that disclosing these records might decrease the public's confidence in our financial system. After our 2008 and sort of continuing financial crisis, I am not sure that withholding information about financial institution operations would really make the public feel any better. But this is a permissive exemption, and so agencies can disclose the information if they'd like, so long as that information does not contain trade secrets or proprietary or confidential information. And finally, we have the geological exemption, which allows agencies to withhold certain information about water wells. The purpose of this one is to protect the nation's aquifers. We don't want terrorists to, poison them or otherwise cause harm to our drinking water supply. So that's the structure of FOIA and how it was intended to operate. And now we're going to briefly turn to how FOIA actually operates today. So FOIA is very susceptible to presidential influence. After the Watergate scandal, Congress wanted to strengthen FOIA to favor more disclosure. And then President Gerald Ford, he was agreeable to that. He thought more transparency would be good. However, his chief of staff, Donald Rumsfeld, and his deputy chief of staff, Dick Cheney, persuaded Ford to veto the bill because they were concerned about the potential for leaks of top secret information. Now, in that case, Congress was able to override the presidential veto, and to offset concerns about security, Congress provided the opportunity for judicial review if the executive branch claimed that there were top secret or otherwise classified information. So after Congress strengthened FOIA, there was a bit more accessibility to government records. Then the Reagan and the George H.W. Bush administrations once again narrowed disclosures by allowing agencies to withhold substantial amounts of information under the national security exemption. Now, mind you, both presidents did have to issue executive orders requiring non-disclosure of that information. Still, it was a really broad decision to withhold a lot of information from the public. Then Bill Clinton was elected president. His administration swung the pendulum in the other direction, and he expanded disclosures under FOIA. Clinton also permitted the release of national security information withheld by previous administrations, as long as those records were at least 25 years old and of historic interest. So during the Clinton years, FOIA had an increased presumption of disclosure. Then George W. Bush was elected. Pendulum swung back the other way. There was a decreased presumption of disclosure. Now, that actually started prior to the September 11th, 2001 terrorist attacks, but it really ramped up after those attacks. Understandably so in many cases. Then Obama was elected, and he almost immediately revoked the Bush restrictions. He issued an executive order encouraging transparency, openness, and accountability. So there was a big expectation once Obama took office that it was going to be a very transparent administration and disclose a lot of information pursuant to FOIA. Unfortunately, the reality is that the Obama administration was pretty bad about FOIA disclosures. And at first it was hard to figure out, was this a concerted effort by the Obama administration to withhold information, or was it just something that happened due to high turnover and lack of training? Well, it turns out that the Obama administration lobbied Congress pretty strenuously to avoid disclosing information, which was the opposite of Obama's stated desire for openness and transparency. So the Obama administration was less than stellar when it came to FOIA. The Trump administration has been even worse. It has ordered agencies to scale back communications with the public and the press. So the reality of FOIA today is that almost no agency is going to get you information within that 10 to 20 day period. It usually takes quite a lot of effort to get information out of a FOIA request. FEMA, for instance, when asked for information about its response or lack thereof to Hurricanes Katrina and Sandy, FEMA took an average of over 200 days to respond to requests. Across the board, processing time for federal agencies for all but the simplest of requests is well over 100 days. Now, this lack of disclosure, it doesn't necessarily stem from the government's desire to keep records secret, although right now it kind of does. And many of these records don't actually contain anything of interest in them. But a lot of agency FOIA offices are not staffed properly. It's kind of the same with procurement offices. People retire and they don't get replaced, and that puts a strain on the whole system. If you've only got 1 or 2 people responding to FOIA requests for the entire Department of Defense or the entire Department of Homeland Security, there's just going to be a huge backlog. And that is where we find ourselves today. Now, if you submit a FOIA request to a federal agency and it is denied, or more likely, you just never hear back from the agency, you can go ahead and seek judicial review by filing a lawsuit. So FOIA, the statute itself, specifically provides for judicial review. After you file suit, the court is probably going to review your FOIA request de novo. It's going to ignore whatever the agency did, which today is probably nothing. And it is going to review the records all over again, or today for the very first time, perhaps. Additionally, a court can examine records in camera. That means that the judge takes the records to her private chambers for review. And this in-camera review preserves confidentiality because the information is not included in the case record. The judge is either going to agree with the agency and exempt the documents from disclosure, or disagree and order that the agency disclose the records. If the case moves on to trial, it is the agency that has the burden of proving that the record you're seeking is exempt from disclosure. Now, in addition to ordering disclosure, courts can also hold an agency in contempt of court for failure to disclose. They can also award attorney's fees and certain other costs to the requester. There is also an Office of Special Counsel. That is an independent office that investigates agencies and agency personnel. And if the Office of Special Counsel thinks an agency is impermissibly withholding records, either because it doesn't want the information to be made public or it doesn't want to put in the time required to respond to the FOIA request, the special counsel can initiate disciplinary proceedings against the agency employees, and it can force an agency to disclose records. Now, unfortunately, FOIA does not permit monetary damages other than attorney's fees and court costs. You cannot get, damages for the time that you have spent filing and pursuing your FOIA request, and you cannot get punitive damages. I think FOIA would have more teeth, and agencies would be more likely to respond appropriately if they knew that they could be hit with punitive damages, but I did not write FOIA, so that is not up to me. So earlier, I talked about EPIC versus the Department of Homeland Security, and That request did turn into a lawsuit because DHS never responded to EPIC. So back in February 2011, DHS announced that it was going to start monitoring social media content. It's actually a little bit surprising that they announced this and didn't just go and do it secretly. But basically, back in early 2011, DHS said that it was going to create fake social media profiles in order to gather information and disseminate that information to law enforcement and Homeland Security contractors. So EPIC wanted to know more about this program, and it submitted the FOIA request. Homeland Security acknowledged receipt of that FOIA request, but then did nothing else. And eventually, EPIC filed an administrative appeal. It was arguing that by dragging its feet for so long, DHS had essentially denied its FOIA request. And as an aside, when the government refuses to take action for a long enough period of time, that inaction is considered a deemed denial. And that is necessary because it allows individuals and organizations to exhaust their administrative remedies and appeal to a court. So without a deemed denial, an agency could simply ignore the request forever. So in this case, Homeland Security did not respond to the appeal, so EPIC filed suit in court. EPIC was seeking injunctive relief. It wanted the court to force DHS to turn over the information requested. And eventually that did happen. DHS wound up disclosing 285 pages of records. Those records showed that DHS had contracted with private companies, including companies like General Dynamics, to monitor social media and other internet communications. They were especially interested in monitoring the comments section of the New York Times and the Huffington Post. Turned out Homeland Security was spying not just on journalists, but just on regular, everyday social media users like you and me. The agency was specifically looking for media reports or comments from individuals that contained negative comments about the U.S. government in general and about the Department of Homeland Security in particular. And as you might imagine, there are a fairly large number of these negative opinions, especially when Homeland Security ignores FOIA requests. So EPIC prevailed, and DHS had to release its records. DHS issues an analyst's desktop binder to its personnel, and in that desktop binder were a huge list of keywords that DHS was using to monitor social media sites like Facebook and Twitter. So again, DHS claimed that it was monitoring these sites to find out, locate threats against the United States. But this slide shows a very abbreviated list of the words that DHS was monitoring. And sure, some of them might be mentioned if you were planning a terrorist attack, but it's a lot more likely that these words were just showing up in everyday, generally uninteresting, except to the person posting and their friends, Facebook posts or tweets. So you might be talking about getting food poisoning from pork tacos in Mexico. That might have triggered DHS to take a deeper interest in your social media account. Same if you are a fan of the Pittsburgh Pirates or if you complain about delays on public transit. Just a lot of these words are just normal words used in everyday conversation, so it was really strange that DHS was drilling down and invading the privacy of regular Americans just because we used some of these words. Now, in other cases, courts agree with the agency and they do not force the disclosure of records. One of these cases stemmed from Colorado. The Denver Post sued because it wanted copies of cell phone bills, including records of outgoing and incoming calls and texts from then Governor Bill Ritter's private cell phone. And the court said no, these are not public records. They are not subject to disclosure under the Colorado Open Records Act, or CORA, because the governor, when using his private phone for his private life, is entitled to privacy. Now, in Maryland, we had a court come down a different way and actually require disclosure of personal cell phone and personal email accounts But that was because the court determined that Maryland state personnel were using their private accounts to carry out government work, and they were doing so specifically to avoid disclosure under the Maryland version of FOIA. So courts rule differently depending on the case, and if a court feels that government personnel were not acting in good faith, the court is more likely to require the disclosure of the requested records. In addition to judicial review of FOIA requests, there is also congressional review. Now, Congress does not do a particularly good job of it, but it does engage in monitoring FOIA requests. So agencies have to submit annual reports to the Speaker of the House and to the Majority Leader of the Senate. Those reports just have to contain some basic information about how the agency is handling FOIA requests. And this is because Congress needs to understand how many requests are coming in, how frequently agencies are denying requests, and how many lawsuits are stemming from those denials. In addition to the agency reports to Congress, the Attorney General also reports on FOIA cases to Congress. Again, covers the number of requests, exemptions invoked by agencies, the monetary costs for the agencies of FOIA compliance, and an explanation of how the executive branch complies with FOIA. Okay, this is a fairly long lecture, I'm sorry, so I am splitting it into two parts. So part 2 is going to cover state open records laws, the Privacy Act, and the Government in the Sunshine Act.